We have a conflict, and we filed a motion regarding that conflict, and an order should be making its way through. We would seek the appointment of regional counsel. So we're going to have to get Jennifer Flowers. Should be your attorney. Okay. And I did mention it to her before she left.
Your Honor, may I intervene in this and maybe facilitate?
You're a party, you don't have to intervene.
I'm sorry, Judge. Sorry.
Go ahead.
The offer would be for Mr. Odom to revoke and terminate a new term of supervision, 6 months community control, and then the remainder of the terms on probation, on standard probation. And then complete your original requirements. That's the offer to close. He would get out. Am I wrong?
No, you're fine. Right, conflict.
Or just modify, not revoke? Okay, Your Honor, just modify, not revoke and terminate.
Sorry?
Just modify, not revoke and terminate.
Okay, so modify and make the, extend it by 6 months, or?
Next 6 months on community.
Isn't he on community control? You're on community control anyways, aren't you? Yeah.
Well, maybe it was gonna be done to extend it, but
Okay.
let's extend by 6 months and then remainder on regular probation.
Your Honor, he's going to be representing himself, and he does want to accept the state's offer.
Okay. All right. Mr. Odom, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. Can you state your name and date of birth, Mr. Odom?
Randall Odom, 3/1/1959.
Hey, Mr. Odom, you're here in 23 CF 730 and 23 CF 1947 for violations of probation. You've heard what the state's announced as the plea offer. Is that something you want to do? Okay, you understand the public defender's asked to be withdrawn from your case because they have a conflict that involves, I think.
He's listed as a witness on another
in
case.
someone else's case. That's right. I didn't want to get it reversed. All right. So the offer would be to modify your probation where the next 6 months would be community control and everything else remains the same, right?
Yes, Your Honor.
Okay, is that what you want to do?
Sir.
All right. Are you under the influence of any alcohol, drugs, or controlled substances?
Sir.
Any mental health issues or concerns?
Sir.
All right. Do you want to speak with another attorney first before you make this decision today?
No, sir.
Okay. Do you feel as if you've been forced, pressured, or threatened in any way to admit to your violation, which will lead to the modification?
Sir.
Anyone promise you anything other than what the state's offer was? Okay, and you understand there won't be a VOP hearing at all where they'll have to prove that you violated your probation in any way?
Pardon me?
You understand there won't be another hearing where the state would have to prove that you violated
Yes, sir.
your probation because you're admitting to it today?
Yes, sir.
Okay. All right, and are you admitting or denying your violation of probation?
Admitting.
Admitting.
Okay. I'm going to accept your admission to your violation of probation in 23 CF 730 and 1947. You'll be modify the probation for the next 6 months of it to be on community control, complete all previously entered terms. The remainder of that term will be on regular probation. Obviously, you'll get credit for any terms that you may have completed, but you got to finish everything out. But it's going to be community control for the next 6 months.
Yes, sir.
Okay. Anything that I've missed?
No, Your Honor. I just have the score sheet I would like to.
Please.
Your Honor, I believe Mr. Odom is on GPS. On GPS? Mr.
No.
No.
No, he's not.
Okay, never mind. Okay, thank you, Your Honor.
Thank you.
And Your Honor,
All right,
we'd ask
this
to
is a downward
continue.
departure based on a uncoerced plea agreement.
Yes, Your Honor.
And Your Honor, we would ask the court, as friend of the court, to continue to waive supervision fees for him.
Of course. Yes. All right, Mr. Odom, step
Because
over
it's
and
valid,
be
you get to keep it.
fingerprinted, and you've got 30 days to appeal the judgment and sentence of the court. Thank you. No, this is a motion.
Your Honor, this is Robert Jeffrey Schofield. He's before the court on 24 CF 2080, 24 CF 1844. He has, we have bond hearing this morning, and then he is set for arraignment this afternoon. I'll go ahead and arraign him for
To
the,
break it to you, Ms. Rivers, it's already afternoon.
yes, okay. Yes.
I know what you meant, but
He is set, Your Honor, to be arraigned on larceny, petty theft on both cases, and we would enter not guilty plea, request trial by jury for that portion, and ask,
for the new case that's
for
set
the-
on this afternoon's docket.
yes, Your Honor, and ask to keep it on the 224 docket.
24 for that.
And then when the court's ready, we can pursue the next issue.
All right, go ahead.
Your Honor, we're also here on our motion to, for bond, to reinstate bonds. Mr. Schofield was arrested on each case, and they're both felony petty thefts. And his bonds, though, were later revoked for failure to appear. But Mr. Schofield said that he understood that the two cases would be combined into one, and he'd have one court date. And he's asking the court to reinstate his bond. He is a lifelong resident of the Panhandle. He says he's a primary caregiver for his dad. His dad had an accident and currently cannot work or see. And he says that he usually works action labor.
I think my concern, and correct me if I'm wrong, is that he didn't make either court date. So to say, I thought they were going to get consolidated, but if you miss both court dates,
Your Honor, I'm guilty of one and not guilty of the other one. I just, and I understand if you don't let me out of jail today, and I'm not gonna sit here and ask you to, but Your Honor, my name is Robert Jeffrey Schofield, and my father's name is Robert Dwayne Schofield. He's been arrested in 2006, 2012, 2014, and 2018 for petty theft. I've been arrested one time at dealers in Pensacola, and one time 22 years ago, and that's the only time. I swear.
I think I could maybe make this relatively speedy. I've reviewed both of the signature bonds in each, the South End and then the North End case, and it looks like jail transposed the location and the date in both of them. So the state is not objecting to the reinstatement of both bonds.
that's the bonds in 1844 and 2080.
Correct. And I believe they were signature bonds.
They were.
I'll reinstate the signature bonds. What were, based on the state's agreement and investigation finding that there was an error on their part? Not on their part, not the state's part, but the jail maybe got it wrong.
Your Honor, I just have one more quick thing. I have a warrant here for Hibbets that was signed on 7/16/2024, and the crime didn't happen until 8/3/2024.
Okay, well, it sounds like you're admitting to crime, so I would tell you.
No, he's saying the allegation is on his paperwork, and I've already mentioned it to the
Yeah,
state.
I've never
I
been into
mentioned it to
Hibbets
him.
and Crestview in my life, and I can prove it if you look at this warrant. Like
Is it a warrant that's been served on you?
it's a warrant that was signed by the officer on 7/16/2024. and-
Officers don't sign warrants, judges do.
Well, the Judge Stone signed it. If you would just take a look at it, you'll see that the alleged crime didn't happen until 8/3/2024. But the officer requested for it to be signed, I guess, on 7/16/2024. And I was questioned about the crime that day, and the
Is that
officer.
one of the cases that's
Okay.
pending?
I'm sorry, huh?
Is that one of the cases that's pending?
Yes. That's why
Is
I
it
was,
one of my cases?
yes.
Okay. What does the paperwork say?
So sorry, it's so crumbled up. I'm so sorry. It says
I
that
don't
the
know what you're
officer.
asking me to do, Mr. Schofield.
Well, the officer swore that on 7/16/2024 that I went into Hibbets, sworn and subscribed that I broke the law of petty theft, but right here, it didn't happen until 8/3/2024.
The police report is very
What case is
inconsistent.
this?
This would be, which one is Hibbett's? Which case number?
This is all this case number.
Okay.
It's going to be the misdemeanor in 24 MM 4361. The two cases before the court, one was the Circle,
Not
I think
even
the
the
Circle
same
K and
case
Destin,
number.
one was at Sefco.
This is one of the misdemeanor cases. This is not my case.
Yeah.
Anything else? I'm going to grant the reinstatement of the bond.
Make sure you're in court on
Everything up to
February
24.
24th.
How do I get out on this, though?
That's something you're going to have to talk over with Charles Hall.
Thank you,
Okay.
Ms. Rivers. Thank you, Your Honor.
Bradley Simmons.
Your Honor, this is Bradley Simmons before the court on violation of probation, 14 CF 2669. If we haven't already entered a denial, we would enter a denial at this time.
Okay.
I know in speaking with him, he had indicated he was going to be hiring private counsel.
Where are you in that process, Mr. Simmons?
So he wants to know where you are in the process of hiring her.
I thought it was gonna be next month, and my mama, she gonna be paid, and I'm gonna hire Miss Dudley. I don't. It's hard.
When is that going to happen?
Probably about. I thought we was gonna be next month. Probably about 3 more weeks. She gonna Miss Dudley
What
probably
would you like to do with your case now?
Continue it so she can,
continue, sir. Can I ask you one question, sir? I mean, I know y'all ain't got time.
I've got plenty of time.
I mean, I when I was sitting on the thing, I said anything in that car is mine.
I don't,
Okay, let's
don't talk about the
don't-
facts of
yeah,
the case.
he don't want you to talk about the facts of the case.
Okay. If I can, I'm trying to. I need some help rehab. Like go to if I can, but yeah.
Well, I'm not negotiating a plea with you, sir.
And that is their offer, remember, is rehab.
Yeah, but yeah, I'm gonna get 3 weeks. I'm gonna try to get a positive turn.
All right, so what day would you like it to continue to?
February 27th or the first time you have in March? That might be cutting it close.
I think it was 26 for inmates.
February 6th or March 27th?
Oh, March 27th. Okay, March 27th.
March 27th. All right.
I'll
If
give
you
you
hire
plenty
Ms.
of
Dudley,
time.
you guys want to come in earlier because you've got some resolution to the case, you can certainly bring it back earlier, Mr. Simmons. Otherwise, we'll see you on March 27th.
Yep, I'll give you time. I just can't right now because I'm in front of the judge.
Timothy Simmons.
Your Honor, this is Timothy Simmons before the court on 24 CF 2736. We've reached an agreement in this matter, if I may approach.
Mr. Simmons, can you raise your right hand, please? Other one? It's okay. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. All right, your name and date of birth, please?
2001.
All right, I've been handed a plea and sentencing agreement in 24 CF 2736, which calls for you to plead nolo contendere or no contest to possession of an ammunition or a weapon by a convicted felon, which is a second-degree felony, and 2 counts of possession of a controlled substance. And it calls for 1 year of community control and 1 year of probation, and bars the bed to complete Phoenix House. Is that what you want to do today? Okay. Did you go over this form with your attorney, Ms. Rivers? Did she answer all your questions? Did you understand the form? Did you sign it? Okay. And are you satisfied with her advice and representation in the case? Are you under the influence of any alcohol, drugs, or controlled substances? And any mental health issues or concerns? Anyone force, pressure, or threaten you to take this plea? Anyone promise you anything in return for your plea? You understand by entering a plea, there'll be no trial of any kind, and you're giving up all your trial rights that are talked about in this agreement. All right, and you're waiving any potential defenses that you may have. Okay, and how old are you and how far have you gone in school? Okay, but you were able to read this and understand it, right? Okay. All right, and what is your plea?
No contest.
All right, I'm going to accept your no contest plea. It's freely, voluntarily, knowingly given. On all 3 counts, it's going to be 1 year community control, followed by 1 year of probation, bars to bed to complete Phoenix House. Does that mean he's on community control when he's in Phoenix House?
Correct. That's what they require.
Okay, just want to make sure it's clear. All right, $515 in court costs, $100 cost of prosecution, $100 PD fee, and $50 application. Waive cost of supervision. Did I miss anything?
I don't think so, Judge.
All concurrent. State's agreement, and it's a guideline sentence. It is adjudication of guilt. All right, Mr. Simmons, step over and be fingerprinted. You've got 30 days to appeal the judgment and sentence of the court.
Yeah, we need to see him, thank you.
Your Honor, this is Ethan Smith before the court on 25 CS 26. Your Honor, he is asking the court to reduce his current bonds. He has a current cash or professional bond in the amount of $1,000 on the petty theft and $5,000 on the fraudulent use of a credit card, and he is just unable to post those bonds. He's asking the court to substantially reduce the bonds to something that he can maybe afford, or possibly an ROR signature bond. And I'm willing to take some testimony from him if the court's so inclined.
Sorry.
Sorry.
All right.
Restitution form basically submitted on this new case.
All right, state's position.
The state would object to the request to reduce bonds in this case. He also has a pending case in this court in 24 CF 2817. They both occurred, I believe he was both arrested within days of each other in December, but he did not have his bond revoked in that case. And that's a 2-count information, and I believe he also has $5,000 and $1,000 cash or professional bonds in those. The state's position is that he also is also based on the fact that he does have a record, significant record of burglaries to both structures, conveyances, criminal mischief, larceny, petty theft, grand theft, that all date back, almost exclusively date back to sentence in March of 2019. 1, 2, 3, 4, 5, 6, and 8 felonies that were disposed of on that date, and he does also have a more recent battery as well. So the state would object to that request.
And Your Honor, just for the record, if I remember correctly, Mr. Smith was sitting in jail when he got served with the warrant on this case that's before the court for the bond hearing. So it's not that he got out and then picked up a new charge. He was sitting in jail and he got served the warrant, and I believe that's why he got bonds in both cases. Mr. Smith has indicated that he has a job that he would be able to get back if he was released, and he is a lifelong resident, him and his family, of Crestview. You sure? Your Honor, in speaking with Mr. Smith, he has now indicated that he does not wish to go forward with the bond hearing. He does want to enter pleas to both cases that he has pending before the court. The offer that had been sent over by the state was for 13 months DOC.
I believe the guidelines was 13.2 months concurrent.
That's for both
Yeah.
28717 and 25 CF26.
Yes,
Yes,
Your Honor.
sir.
You have a plea form that you can use?
I can, Your Honor, if we bring them back, give me the opportunity because I've got more people coming up.
If we could, just to make it cleaner, because the one's
Yes.
not on the docket.
Yes.
Frankly, I had to go back and forth. I wasn't convinced that there's two separate cases at one point, because I don't know, maybe there's two different.
One's a credit card case and one's a drug case.
I definitely understand that, but for some reason, they stuck one of the reports regarding the credit card case in the case that's involved with the drug case. So I wanted to make sure there was actually two separate cases. I think they just cross-filed some paperwork, and I want to make sure it's clear that what he's pleading to.
And if, Your Honor, if we could bring him back later this afternoon, I know I have a hearing in front of Judge Ward with him as well, but just to give me a time to write up.
Sure, that's fine. We'll bring him back. We'll get it done this afternoon.
Yep, we'll get it done today.
We'll get it done today.
Okay?
You're alone. Go ahead. Just wait by the door.
Your Honor, this is Nicole Smith. She's before the court on 22 CF 2049, 22 CF 2626, 23 CF 1047. We're here for status. I know that she had wanted me to file a motion for furlough. There was a discussion last time in court that the previous judge had indicated that if she had provided documentation, no, she's not agreeing to it yet. If she had provided documentation of doctor's appointments that the court would agree and the state would agree to furlough, but it had to be provided to the state first. And so I provided the information that was faxed to me to Ms. Leone, and Ms. Leone has indicated that she had wanted some more information.
Yes, Your Honor, the information that I got was a note, a fax, scheduling an appointment as a new patient. So I asked, does she have a procedure already set, or she's a new patient? Because it makes a difference, and I don't have any other documentation.
I don't want to ask questions because it feels like I'm asking medical questions, but I think I need to hear a little bit more than that myself.
So, if you would, tell them about your hip.
Absolutely, yes, sir. So I have gotten into a motorcycle wreck, and I've shattered my pelvis. And so before I got picked up and I was out, I had scheduled an appointment with a primary care physician to get a referral for a surgery because of my insurance. Well, that was why we asked for the furlough, was because I already had that in the process. It took me several months to get insurance because at the time of the motorcycle wreck, I did not have insurance. So let me explain from the beginning.
No, you're good. You're good. Just
Okay. So I had 2 plates, 12 pins and screws, and 1 rod in my hip from a previous injury. When I wrecked my motorcycle, that is when it re-broke it. In Tallahassee, they released me because I had no health insurance. So I stayed 24 hours in the hospital. And I got insurance, made an appointment, but I got picked up in the meantime to get the process going.
An appointment with who? A primary
It
care?
was a primary care because I had an HMO at the time, so then I had to get a referral. The jail has x-rays.
Someone's going to have to give me more than that, because an appointment to get a referral is not really
Well,
reason for a furlough.
This appointment is not for primary care. This appointment is for an orthopedic surgeon.
Just asked that question.
I'm sorry, I misunderstood. I apologize.
Judge, what the
I
state was
apologize.
provided with was a primary physician, not a
Yeah.
specialist.
Yeah.
Dr. Adams?
No, that's not the sheet that we got. The sheet that we got.
Is it for the
Where are we at
third?
with the case? Where are we at with the case? What do we do?
Your Honor, at this point, she is wanting a continuance. She and I had discussed the state's offer, and I believe she wants to try to pursue,
This was not, I'm sorry.
yeah, you're good, a downward departure based on medical needs. We don't have any documentation at this point. So at this point, she
What's
is
the score? What's the guideline?
30, no, it was 20-something months.
23.
23, around 23 months, but the state was asking 30.
27.6 months is the minimum guidelines.
The state was asking 30.
I was asking for 30 months.
30 months.
Would be the second violation of probation on the cases.
Make sure I understand. The warrant was sought in September of 2023 for absconding. It wasn't served until October. So over a year after the allegation of absconding. And now you want me to let you out to go to a doctor's appointment.
Here's the thing, when I left Keaton, and I left Keaton, and I understand that, but I went back to my address that I had on file, the probation had on file, the sheriff's department here has on file, my probation officer here has on file. That's where I've been the whole time. I know that's not an excuse, but that is the actuality of it.
When did this accident happen?
It happened at the beginning of last year. It took me 7 months to get a doctor's appointment.
Oh, okay, so while you're allegedly absconding from your probation, you didn't check in during that time, is what I'm reading. I'm not asking you that question. I'm not asking for a response. But you didn't try to reach out in any way according to what I've seen, and you also got into a motorcycle wreck during that time, and that should be a reason why you get out of jail when you've absconded for over a year, according to the allegations. If you give me something that you have to go see a particular specialist about a particular issue, I'll reconsider it. I'm not saying I'm going to grant it, but doctor's appointments, you know, are not enough for a furlough unless it's something that absolutely is emergency. You know, I had a situation where there was someone in the jail the other day. They were concerned about her medical issues, and everybody in the system moved heaven and earth to get her out of jail because of it was that serious. This is not. So we're going to handle the case, and then you can decide what you're going to do. Give me some more information. I'll reconsider it. So the motion is denied without prejudice.
And, Your Honor, if we could set this on for the March court date?
All right, the March 27th date?
Yes, Your
All
Honor.
right, March 27th, 9 o'clock.
Your Honor, the next one listed on the docket is Christopher Stearns. He should be approaching. Your Honor, this is Christopher Stearns, 24 CF 1853, 24 CF 2625, We have a conflict on this case. We filed a motion with the court regarding the conflict. I did speak to Ms. Flowers about that while she was here in court. So Ms. Flowers is going to have to take over your case again, okay? Because the conflict's still the same as before. I believe you put the other one maybe on the
I'm gonna put on the 6th.
6th,
just to see if she
February
has-
6th.
Just, it's 1 week, sir. See if she can get in, talk to you, or at least talk to you when you get to court here next week.
Yes, sir.
Okay, so I'm gonna grant the order to withdraw. Is this it? Sign that, appointing the Office of Regional Conflict Counsel. Ms. Flowers will be your new lawyer, Mr. Stearns. I'll see you back in a week,
Yes, sir.
February 6th.
All right.
Weathersby we handled, right?
Yes, Your Honor. Your Honor, this is Joseph Wechter. I provided him with the plea offer for him to read. He's just now going to need to sign it now that he's out here, and I can give him a pen. Okay, you need to sign it right there. Did you have any questions?
I have.
We don't need the score sheet, right? Why is it on? It's mine.
They probably thought it was
But you,
Oh, is that you?
we can't do this, jail, he has to adjudicate.
Probably sent it to
How much time,
court personnel, not the clerk's
how much
office.
time has he got?
I think over 21 days.
I'm gonna do 21 days.
Okay.
It was set to.
Date on this.
All right, Mr. Wechter, you raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
All right, your name and date of birth, please.
Joseph Kazmar Wechter, 11/12/1978.
And you're here in 20 CF 2187 on a violation of probation. Did you go over this? Well, is this a, actually, it's not a violation of
It's
probation.
not a violation of probation, Your Honor. It's a new law charge.
It's a really old case.
Yeah, yeah. He actually had, he did the program, the mental health program, the 12-week program, and he completed it. Then he had a court date. Then he didn't make the court date. Then it was these years later, and now we're back.
The state's intention was to do the withhold. And so I think actually the offer could just be withhold and,
Unserved.
yeah, court costs.
I can't put him
Because
in jail
otherwise-
with a withhold.
That's correct.
Unless there's probation, like we did with the other person earlier.
So that's what we'll do.
All right, so just no jail, credit for time served. I'm assuming you're okay with that, Mr. Wechter?
I'm okay with that.
Okay. Did you go over this plea and sentencing agreement with your lawyer?
That would be me.
Yes, of course I did.
Did you understand that? And are you satisfied with her advice and representation in this case?
I'm very satisfied.
Okay. Are you under the influence of any alcohol, drugs, or controlled substances?
No.
Any mental health issues or concerns?
Nope.
All right. Anyone promise you anything in return for this plea? Anyone force, pressure, or threaten you in any way to enter this plea?
Nope.
You understand by entering a plea of no contest that you'd be giving up your right to a trial and all your trial rights that you read about in this paperwork? You understand that?
correct.
Okay, and you understand you're waived any potential defenses that you may have? All right. What's your plea?
No contest.
All right, I'm going to accept your no contest plea as freely voluntary and knowingly given. Withhold adjudication, credit for time served, $4.15 in court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. I'm going to give you 90 days to go either pay the money or set up a payment plan with the clerk, okay? All right, any questions?
No questions.
All right, this is a guideline sentence. He doesn't score. All right, you have 30 days to appeal the judgment and sentence, Mr. Wechter. We'll see you around. Thank you.
Good
Very
luck.
much. Okay.
Hey, Gary, come stand over by me. Judge, this case was set for today to see if it could either be worked out. We've got the primary witness on it scheduled for deposition next week, and so we're going to go ahead and leave this case on. We may be able to bring it in earlier.
Leave it on for what?
Excuse me?
What date?
2/24, Judge.
Okay.
No objection.
All right. February 24th for pretrial conference.
Yes, sir.
Is that going to be, you think, a potential agreed upon? I know you talked about possibly pleading to the bench last time.
Judge, it doesn't look like we're going to be there. I've spoken with the prosecutor again. I've spoken with my client again. At this point, my client wants a trial. We're going to take the deposition. The prosecutor is going to be less insistent on a straight-up plea, and we may be able to get it worked out.
That's correct.
Okay. February 24th.
Thank you, sir.
Thank you.
Okay, I'll come out and see you after I get the depo taken.
Thank you, Gary.
Sorry, Judge, I have to go back to Mr. There we go. All right, Judge, the plan at this point is to leave it on the docket for 2/24. Let me get Sue's number here. He's giving me some additional information, and I've spoken with the prosecutor about we may be able to get it brought in earlier. Okay.
All right, February 24th.
Thank you, Judge.
Thank you, sir.
Yeah,
Okay.
yeah, after I talk with her. Okay. Judge, this is going to be a negotiated plea for time served. Now, while he's signing that, Judge, talked with the state. This whole situation arose because he's got is required to wear a GPS unit as part of his supervision. The house that he lives in has a tin roof, and so the regular GPS signal is not able to reach the satellite when he's inside. So the solution that was proposed for that was to allow him to have internet access in the home, just no internet-capable devices other than his GPS unit. Looking at the two different violation reports, is an initial one that was really done sort of a notification to the court, and the recommendation was to, modify his supervision to allow him to have that internet service. And then another one within 10 days before the court ever signed the order allowing him to have internet. Changing from a new violation or amended violation and a recommendation of state prison. And that's why I wanted to take the deposition. That didn't turn out to be possible because the assigned assistant state attorney was not available. But we've managed to work it out. But we still need to get his terms of supervision modified so that he can have internet in the house, just no internet-capable devices. Otherwise, we're going to be back here again in a week. Now, our office will remain his attorney for 30 days for purposes of him maybe deciding to file an appeal. Since I'm already still his lawyer anyway, if the court needs me to draft something up for that, I can do that.
Hold on, an appeal of what?
He's not going to be. I'm talking about jurisdiction from my office.
Okay, I was just.
Once he enters,
I haven't made any decisions. I'm not sure what I've done wrong yet.
once he has signed this, once this is accepted by the court and the court sentences him, normally we wouldn't have anything further to do on the case, but we're still on the hook for 30 days in case he did want to appeal. Since I'm on the hook anyway, I don't think it chaps anybody if I go ahead and try to help out and get an order done on this, if that's what we need, or if it's something that can be done through the clerk's minutes. That makes my life easier.
Modify it?
Yeah, to allow him to have internet in the house. I think that's what everybody's wanting.
What's the state's position?
The offer in the state's position was to admit, be adjudicated, credit for all time served in the county jail as part of the sanctions, and statement all original terms and conditions with the
exception
modification that he may access the internet for full purposes of the GPS.
I don't have any issue with it. I'll just be very careful about it, Mr. Johnson.
Yes, sir.
I wouldn't, I'm not trying to give you legal advice, but you probably shouldn't give whatever your Wi-Fi password is to anybody, because if anybody uses it, someone's going to accuse you of it at some point.
Thank you, sir.
I'd be very careful about that. Do y'all have a written agreement?
Judge, I don't have the terms of modification on the agreement. My thinking was that the court was going to ask me to do a motion to modify or something like that.
I mean, we're already here changing everything. I mean, the plea agreement allows for the modifications. I don't think we need to do that. If you want to write that
I'll
use
write
the
it
language
in.
you want, and then I'll announce it.
All right, Judge, what I've done is I've written on here, probation modified to allow internet for GPS purposes only.
Any language different than that?
No, Your Honor, that's acceptable to the state.
Okay, Mr. Johnson, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Johnson, you heard all of the stuff that we were just talking about,
Absolutely.
but I'm going to spell it out for you. So in 18 CF 607, you've looked over this violation of probation plea agreement? Yes?
Yes, sir.
Okay, and did you do that with your attorney, Mr. Williams?
Yes, sir.
And did you understand everything in it?
Yes, sir.
Did he answer all your questions?
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
All right, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues or
No, sir.
concerns? Anyone promise you anything in return for your plea?
No, sir.
Anyone promise or force, pressure, or threaten you in any way to enter this plea?
No, sir.
You understand there won't be a violation of probation evidentiary hearing because you're entering the plea?
Yes, sir.
So the state won't have to prove anything against you going forward on this part? Understand that?
Yeah.
Okay.
Yes, sir.
You understand you're waiving any potential defenses that you may have?
Just for this
For
violation?
this particular violation.
Yes, sir.
The
Yes,
way
sir.
I said that, I know why you're confused, so
Okay.
let me make sure I rephrase it. You
Yes,
understand
sir.
they won't have to prove anything as far as this
Okay,
violation?
yes, sir.
Because you're entering the admission. All right. What is your plea to the VOP? You admitting or
No
denying?
contest. No contest.
Well, admitting or denying the violation of probation?
Admit.
All right. I'm going to accept your admission to the violation of probation. Be time served for the violation, you're to remain on your previously imposed supervision with the same terms and conditions, with the exception that we're going to modify your probation to allow you to have internet or Wi-Fi signal inside of your house to be used only for your GPS device. That means don't log anything else into that Wi-Fi. Like, someone comes by, hey, can I use your Wi-Fi real quick? No. Don't even let people know you have it, probably is the better way of
Yes,
doing
sir.
it. There's also going to be a $100 cost of prosecution and a $150 PD fee, adjudication of guilt. Was this a guideline sentence? I guess it's just a modification.
No, it's a, yes, sir.
All right. Anything else, Mr. Johnson?
No, sir, that's it. Thank you,
All
sir.
right, you've got 30 days to appeal the judgment and sentence of the court.
And Your Honor, he's on GPS, is that correct?
Yes.
Remain in custody until the GPS is attached.
Yes.
He was already on GPS. Good luck to you, Mr. Johnson.
He has to remain
Yes,
in
it stays with
custody
you.
until
Sir?
GPS is attached, is
Sir?
that correct?
Mr.
Your
Johnson?
Honor?
That's okay, just have a
Judge, probation's going to need a yes from you.
Is he to remain in custody until GPS is attached?
Yes.
Thank you.
Do we expect a delay to that?
Once we get back and the clerk gets the minutes out to the jail contacts us, and then we go out to hook him up. We can't go out there until the jail contacts us, that he's ready to go.
Okay.
It probably, I can't promise you it'd be the end of the day. I don't know when he gets back.
It
to
might
the
be
jail.
tomorrow, Mr.
Oh,
Johnson,
yeah,
is what he's
yeah.
saying.
No doubt.
All right, next case.
No.
Kevin Judy.
Or
credit that I would actually.
Judge, he wants me to figure out what his credit's going to be for him, so I don't know how we're going to be able to do that today. Can we bring him back?
What's the offer?
The offer is 15 months DOC, each case concurrent with credit for time served since the date of his hold from Florida, which is 8/29/24.
Well, sorry, I had 2 months prior and then 5 months also of incarceration on this case. That's what I was asking about is the 7 months be added to that.
When you were initially arrested,
All right, I'm gonna let y'all talk about this. We're
Let's-
still
let's
on our
just-
9 o'clock docket, and these things can be figured out in a different way. If you want to recall them later, if you get a chance to talk to them back there. or
I
something.
don't
But we're
know
not gonna
that
do it in
I'm
the well.
going to get that chance, Judge, but let's set him that way for right now, and I'll try.
All right,
Thank you.
we're on our 9 o'clock docket, and it's 1:15, so I'd like to get moving on these issues. Hold on to them for now.
Okay.
Yeah.
Let me know so we can go back.
I will.
Mr. Lucero.
Okay.
Morning, sir, or good afternoon.
Okay.
All right, while they're doing that, Mr. Lucero, you want to raise your right hand so I can swear you in? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and date of birth?
Travis Burton, Lucero, 1998, December 14th.
All right, Mr. Lucero, are you under the influence of any alcohol, drugs, or controlled substances? Any mental health concerns?
No, sir.
Okay. Did you go over this plea form with your lawyer, Mr. Williams?
Yes, sir.
Did he answer all your questions?
Yes, sir.
You need more time to speak to him about it?
No, sir.
Okay. You satisfied with his advice and representation? Yes? Okay, I just need to be able to hear you. All right, thank you, Mr. Williams.
I'm sorry, I had.
That's fine. I just figured I'd get ahead of the game with some of the questions I have to ask. All right, so in 23 CF 1152 and 23 CF 2242, these are violations of probation. Is that right, Mr. Lucero?
Yes, sir.
And you've gone over this document with Mr. Williams?
Yes, sir.
You understand it?
Yes, sir.
All right. Did anyone promise you anything in return for your plea? Other than what's in the agreement?
Yes, sir.
Okay. Anyone force, pressure, or threaten you in any way?
No, sir.
All right. Do you understand by entering an admission to your violation of probation, you're giving up your right to an evidentiary hearing where the state would have to prove that you violated your probation? All right. You understand you're waiving any potential defenses that you may have? All right. And are you admitting or denying your violation of probation?
Did he?
All right. I'm going to accept your admission as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty, modify the terms of your probation. The next 6 months will be on community control. Do you understand that?
Yes, sir.
All right. And then with the balance of your original term is restored to regular probation, all original terms and conditions, $100 cost of prosecution, and each of the cases, and $150 total public defender fee. Do you understand all that? All right. All right. I'm going to need your fingerprints, 30 days to appeal the judgment and sentence of the court. And it's a guideline sentence, just barely.
Go ahead and have it.
43.24.
Robert McDonald.
Judge, my last conversation with Mr. McDonald, he wanted to represent himself.
Okay.
So if the court will conduct the Ferretti hearing for him.
All right. I have it in here. All right. Mr. McDonald, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do, Your Honor.
All right. It's my understanding you want to represent yourself. Is that right?
Yes, sir, I do.
All right. How old are you and how far did you go in school?
I am 52 years old, and I completed 11th grade
Okay.
and joined the Army.
Okay. And you're here in 24 CF 1950 where you're charged with possession of a weapon by a convicted felon, tampering with evidence, possession of a controlled substance, driving while license suspended, possession of drug paraphernalia, and resisting without violence. Do you understand all those charges?
Yes, sir, I do.
All right. Have you ever been through the court system before?
Yes, sir, I have.
There's a plea day. All right. Have you ever represented yourself before?
Yes, sir, I have.
Okay. And when was that?
In October of 2024 on a domestic case, and prior to that in 2023 on CF 46-2020, 1357 case.
All right. So you also have currently 24 CF 2917.
Yes, sir, I do.
Pull that case up so I make sure those the charges are. What was your result when you represented yourself previously?
The last year case in October was resolved and dropped. And in the 2023 case, I think I combined it with the other charges, and so I
How
got,
old did you say you are, Mr. McDonald?
sir,
How old did you say you are?
52.
All right, so in the new case, in the 2917 case, you're charged with escape, vehicle theft, criminal, 2 counts of criminal mischief, petty theft, resisting without violence, and disturbing, no, I'm sorry, resisting was not filed.
I only have 5 counts here, Your Honor.
That's what I just said. The last one I just said wasn't filed.
Okay, I'm sorry.
Okay, it's okay.
Yes, sir.
All right, do you understand the advantages that that a lawyer gives you as far as, knowing the laws of evidence, and those things?
Yes, sir, I do. And I understand that only a fool represents itself too. But I feel at this point in time that it's in my best interest to do so.
Why so?
Well, because, Your Honor, at the last meeting that I had with Mr. Williams, he ignored me 3 times when I was trying to explain to him.
Let me make sure I understand then what you're asking for, Mr. McDonald. Are you asking to represent yourself, or are you asking for a different lawyer?
No, I'm asking to represent myself, Your Honor.
Okay, so you don't want me to inquire as to whether or not Mr. Williams hasn't done an effective job for you and appoint someone else?
No, sir, I do not.
Okay. And do you understand that you're going to be held to the same rules and statutes as a lawyer would?
Yes, sir, I do
So
that.
you have to understand, evidence code and the rules of criminal procedure.
Yes, sir.
Okay, do you think you can do that?
Yes, sir, I
Have you
can.
ever studied the rules of evidence or any Florida statutes?
Yes, sir, I have. I've been diligently working on these cases for a while.
Okay. You understand? Do you understand that you could, the maximum punishments that you may face if you're convicted of all these charges?
Yes, sir, I do.
Okay, so how much for the escape?
5 years.
Okay, how much for the vehicle theft?
5 years.
How much for the criminal mischief over $1,000?
5 years.
You got 2 of those, right?
Yes.
How much for the petty theft, 2 or prior conviction, so that's a felony 2, right?
Yes, sir, it is.
Okay, so that's 25 years on those, right?
Yes, sir, it is.
Okay, and on the other case, let me make sure I'm looking at the exact charges. Actually, it's not, it's listed in one place, possession of a weapon by a convicted felon, but it's actually carrying a concealed weapon by a convicted
Right,
felon.
yes, I know.
Second-degree
It's
felony,
kinda-
right?
Yes, sir. The language
So you
is a
get
little
15 years
confusing.
for that, correct?
Sir, yes, sir.
All right, and there's a 3-year minimum mandatory on that, is that right?
I think
Yes.
it was a knife, Your Honor, not a firearm.
Oh, it was a knife?
Yeah.
Well, no, I'm looking at the
me see.
information, it says it's an AR-15 semi-automatic rifle.
Okay, then, if you had it on him,
I don't know that it was charged,
Yeah, I don't know.
actually possessed as opposed to constructively.
Yeah.
Actual possession.
Yes.
For it to,
Right,
fall
because
under
within the
the
statutes, Your Honor, it does state carrying possession.
I know what the law is.
I'm sorry, sir.
I'm just trying to make sure you understand what it is.
Yes, sir. Meant no disrespect.
Take it as that, but. All right, so you can get up to 15 years for that, then you've got the tampering with evidence, that's a 3rd-degree felony, so 5 more years for that. Possession of methamphetamine, I'm not saying this is what you're gonna get, I just wanna make sure you understand.
Yes, sir, I understand that.
That's another 5 years. And you've got some misdemeanors, which the 2nd-degree misdemeanors, 60 days, and 2 first-degree misdemeanors a year each, 1129.
Yes, sir.
You understand all that?
Yes, sir, and that's the ceiling of the,
That's the maximum.
Yes.
Yes, sir. are there sentencing guidelines for him that have been developed yet? Just so I can tell you what your lowest permissible sentence would be.
Yes, Your Honor. Okay, the minimum permissible would be 62.25 months, and the total maximum that he's facing is 61 years.
Okay. All right, so if you don't convince me by preponderance of the evidence that I should downward depart if you were to be convicted of these, I've got to give you at least 62 months, 62.25 months. You understand that?
Yes, sir.
All right, do you have any questions for me?
No, sir. I
About
don't.
your self-representation? Okay, so every time you come up from now on, if I allow you to represent yourself, I'm going to ask you a lot of these same questions. You understand that?
Yes, sir.
Okay. All right, are you sure you want to go forward without an attorney?
Yes, sir, I do.
PD's going to be withdrawn. What would you like to do with your case today, Mr. McDonald?
Thank you, Your Honor.
What would you like to do today?
I'd like to represent myself.
I understand. So what are we going to do with your case going
I
forward?
wanted to ask the state if they would accept a counteroffer.
You're free to put it on the record if you'd like.
Sir?
You're free to put it on the record if you'd like.
Yes, and for the record, I was asked to plead no low contender, waive all probation fees and court costs, 3 years probation followed by a 60-month suspended DOC sentence to include driver improvement license class with 180 days after release of that. Allow defendant to transfer his probation to his current address in Walton County, Florida at 659 Juniper Lake Road, Teaneck Springs, Florida. And I want to advise the state attorney that even though if this was even to take place today, I still have a case in Walton County to go to, that I would not be released today. I had to wait, go to court over there, and try to get that run concurrent as a global thing with this
Okay.
right here.
I understand. Does the state want to talk, put anything on the record as far as the counteroffer?
Yes, my offer is 10 years DOC.
And yours is the offer. Okay. All right, so would you like to set your cases for trial, Mr. McDonald?
Yes, sir.
All right, so we'll put you on the February 24th docket for purposes of a pretrial conference, and then
Yes,
we'll
sir.
see how quickly we can get you on the trial docket.
Yes, sir.
All right, thank you, Mr. McDonald.
Thank you.
If you have reconsiderations about an attorney, you make sure that's known to me. All right, thank you.
Judge, we're here this morning. He's got VOPs this morning. I've also scheduled a bond hearing for him. And then he's got another new case that's scheduled for arraignment later this afternoon. Actually, in 4 minutes this afternoon. And I'd like to go ahead and arraign him on that today as well. But if we can go ahead and do the bond hearing.
All right, go ahead.
All right. Judge, in the interest of time, I'll just go ahead and go through the motion. He's been incarcerated since his arrest on December 29th. Right now, he's got a no bond on the VOPs. There's obviously nothing he can do to satisfy that bond. He is employed with Taco Bell. He has been for the last 2 years. He's would reside at 5707 Fairchild in Crestview, and I believe that's not the marital home. Is that right?
Yes, sir.
Okay, so he would live someplace else. We anticipated that the state of the court might want him to. He's been living in this area for approximately 29 years, and what we're requesting, and I filed a motion on each one of his cases, what we're requesting is a signature bond on each of his cases.
All right, state's position.
Judge, the state objects to the defendant's request. He's not entitled to bonds in the 2 violation of probation cases.
That's 24 CF 1357 and 1358.
That's correct. The state would note that the new offense, 24 CF 2894, for which he has arraignment today, is an aggravated animal cruelty case. And the state would note that he has a history of arrest for similar charges. The last such time that he was charged with that was dismissed recently. That was September of 2024. So the state's position is that he is a danger to the community, including the animal community, and that he's not entitled to the bond on the violation of probations, and we would ask that you deny the motion.
Judge, I represented him on the earlier case. I can provide some information on that. Judge, it was determined at deposition with the veterinarian that treated the cat, that actually the injuries were not severe. Our position, and that's why the charges were dismissed by the previous prosecutor, our position on that throughout had been that he had accidentally stepped on the cat's paw, and when the veterinarian examined him, there was no actual damage. The cat had bled some, but there was no permanent injury to the cat. The injury was not severe, and so the former prosecutor announced that he'd be dropping the charges in the deposition.
His new case is aggravated animal cruelty and possession of fentanyl. while
Yes,
on
sir. He's got
probation.
a drug case associated with that. Obviously, we're not going to know the nature of the injuries until we get a report. At this point, discovery's not been provided, so we don't know anything about what the vet's going to say with regard to particular.
Well, we do know what's in the police reports.
Well, and we had that too, and a lot of times these things look.
It was a cat.
All right, let's just say the cat situation is not there. It's still possession of fentanyl while he's on probation. I think your client wants to say something, Mr. Williams.
Judge, I'll let him speak.
Understand that anything that you say can and will be used against you, Mr. Moore. Go ahead.
Just at the time, whenever I was arrested, the officer had came to.
I'm going to stop you for a second again and make sure you understand that everything in this room is recorded and the state attorneys are listening to you. So if you say anything that's incriminating, this evidence is going to be played during your trial potentially. Do you understand that?
Judge, can he be placed under oath, please?
Raise your
How
right
about
hand.
we do it this way? I'll just present to the court what I think part of the defense is going to be in this case. Judge, is that he was awoken from a dead sleep. He just threw on some clothes that were available. I don't even know that they were his, and that he was unaware that the fentanyl was in the clothes.
These aren't my pants defense.
Sometimes that's.
Okay. All right. State want to argue anything else?
No, sir.
All right. Anything else, Mr. Williams?
No, Your Honor.
All right. Bonds will remain the same. It's no bond on the VOP, $22,000 total cash or professional on the new case.
On the new case, I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury.
All right. We'll put, looks like he's set for February 24th.
Thank you.
It'll be in the afternoon.
I believe the score would be 23.25 months DOC, and that would be the offer.
So, all right, I'll come back and see you once I get discovery in. And we'll schedule that depo as soon as we get the name.
Is that the last of the 9 o'clock?
That's the last of the ones that I have for this morning, Judge. Oh, and Judge, what's my date on the new law violation?
224.
224?
224. Could be 226 since he was incarcerated, but
Yes, sir.
we're going to spread those out. Mr. Nopes, what have you got? Yes, sir. Is that about your case? Okay.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Is he here? Okay, just want to make sure if I didn't talk to him. Yeah, here he is.
Hello, this is Chris Norman at Bulldog Bail Bonds.
You can go out to
Our
some-
office is in Crestview, Florida, but we
All right.
service
Do
7
we have anything
Northwest
else on the
Florida
9 o'clock
counties.
docket?
If you ever find yourself in a jam, please give us a call.
Passed
We're here to help you
two.
out.
One
There were,
was,
for the lawyers to talk to their clients to see if we're going to bring them back, right?
right, that one was Mr. Smith was the bond hearing, then he said he wanted a plea with Ms. Rivers.
I think she was going to talk
She
to
didn't
him,
have the
though.
form.
He was gonna go back,
I think she's going to talk to him to get him to do the form.
Oh, she's doing that now? So we-
I can't say that for sure, but I can guess.
She's at lunch right now, Judge.
Okay.
Or this afternoon's people.
Okay, well, we're just going to start going through the 1:30 docket with who's here. Mr. Nopes, you're here on Bradley. Is it Geis? Giese 24 CF 2875. You've entered a plea of not guilty on his behalf. Just hasn't been processed yet, but you're here for him today.
We filed it a little bit ago.
All right, we're going to put you on the February 24th at 9 a.m. docket for pretrial conference. All right, thank you, sir. You too. All right, let's just start at the top. All right, Sheena Anderson.
And Judge, on Ms. Anderson's case, PD was appointed. We'll send an order relieving us, but a private attorney did file an appearance. Lead from Tampa, Judge.
Jerk. Okay. 428.
Is that a plea day, Judge?
Say again?
Is that a plea day?
No, that's a pretrial.
Oh, she entered, they did a.
They entered a plea of, a written plea of not guilty.
Yes, sir.
That's the day that's listed on my docket, so that's what it gets. All right, Jake Bell.
Charles Russell, Public Defender's Office. Judge, this is Jake Bell. Case number for the record is 24 CF 2907. State has filed an information. We enter a plea of not guilty, request trial by jury, 15 days to file any pre-arraignment motions, and set it for pretrial conference day.
All right, February 24th. All right, Jerry Blackshear. Jerry Blackshear here. All right, ROR bond says 30th of January 2025, 1:30 p.m. It's now 1:38. State.
APS, Judge?
APS no bond on Mr. Blackshear. Obviously, if he shows up late, we can revisit it, but. All right, Durante Bryant.
Charles Russell, Public Defender's Office for Mr. Bryant. Judge, case number for the record is 24 CF 2876. State has filed an information. Going to enter a plea of not guilty, request trial by jury, 15 days to file any pre-arraignment motions,
All right, February, go ahead.
and set it for pretrial conference.
All right, February 24th, that's going to be 1:30, Mr. Bryant.
Yes, sir.
All right, Joshua Carver, did we handle that one already?
We handled that this morning, Judge.
Awesome. Just didn't cross it off for some reason. All right, Ladarian Chamberlain.
Charles Russell, Public Defender's Office.
All right, hold on. I don't need the hand signs from the back. Happens again, you're out. Go ahead, Mr. Russell.
Thank you, Judge. This is Mr. Chamberlain. Case number is 23 CF 2420. Information has been filed. We're going to enter a plea of not guilty. Request trial by jury, 15 days for any pre-arraignment motions, and set it for a pretrial conference.
February 24th, so it'll be, what's his bond at this point?
You may not have a bond, Your Honor, based on the charges.
That's on, was there a pretrial detention order or something?
One that
Came back from the federal government. Yes, he was being federally prosecuted, and in this case, we're not relinquishing jurisdiction. We're going forward with the charges. The
Well,
state is.
and I thought I saw an old first appearance that said
It may have, let me verify, I don't remember.
There wouldn't have been a mandatory pretrial detention. This is before they had that rule.
It's before the rule, yes, Your Honor.
I just want to find out if he's got a bond, if he could potentially bond out. Otherwise, we can just go ahead and tell him it's going to be February 26th
sir.
as far as an in-custody PD.
I was right, Judge. So according to the first appearance paperwork done on December 26, 24, Judge Ward gave him, well, the judge at first appearance gave him a $100,000 bond previously set by Judge Ward.
Okay.
Or, no, $1 million, cash for.
All right, Mr. Chamberlain, your next court date's going to be February 24th at 1:30 if you're released. Otherwise, it'll be the 26th.
Steve, it's going to take me a couple of minutes.
Jace Conway.
It's going to take me a couple of minutes. Go ahead and cancel them.
Clarity. Okay. 2:24 at 9. All right. Ashley Cook. CF 2868. Ms. Cook, you were charged with vehicle theft. Do you understand that charge? I need to hear you. Okay, sorry. I can see you nodding, but the microphone can't, so. All right, Ms. Cook, can you afford a lawyer to represent you? You want me to appoint a lawyer to you? All right, I'm going to appoint the public defender. You're going to have to fill out that application and turn that in downstairs before you leave.
Jury information. Judge, and information has been filed, so at this time, we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, and set it on a pretrial conference date.
2:24 at 1:30. All right, Tristan Derrick.
Charles Russell, Public Defender's Office. Judge, this is Mr. Derrick. Case number is 24 CF 2832. Information has been filed. At this time, we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, and set us for a pretrial conference date.
All right, February 24th, 1:30. Mr. Derrick, we'll see you back on that date. Stay in touch with Mr. Russell.
Call next week to make an appointment.
Willie Farmer. 24 CF 2940. Public defender's been appointed.
Correct, Judge. Charles Russell, Public Defender's Office. On Mr. Farmer's case, and information has been filed. At this time, we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions. Asked to set it for a pretrial conference date. Also would note for the record, we recently filed a motion to withdraw, so he will be getting RCC. I don't believe the order's been entered yet.
Judge, the state's not going to go forward in this matter against Mr. Farmer based on the co-defendant being recently having pled to the same substances.
All right, so state's making an announcement?
A different defendant, yes, sir. The state would just null process matter.
Case dismissed. Mark Fonte. 24 CF 2899. Public defender's been appointed.
Judge, in Mr. Fonte's case, state has filed an information.
Put our hands out of your pockets.
We're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions. Ask for a pretrial conference date.
February 24th, 1:30.
Next week, making a thank you.
Thank you, sir. Fonte, we'll see you back that day. Ian Forrester. Twenty-four CF 2878, PD's been appointed.
That's correct, Judge. Mr. Forrester's case, state has filed an information. This time, we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, ask for a pretrial conference date.
February 24th, 1:30. Holly Fowler.
She's in custody. Okay. Okay.
Make sure we get back to her. Donald Garrett. 24 CF 2901, PD's been appointed.
Correct, Judge. Mr. Garrett's present and approaching. At this time, state has filed an information. We're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, and ask for a pretrial conference date.
All right, Mr. Garrett, come back on February 24th at 1:30. Stay in touch with your attorney.
Judge, may I just briefly make a
Stop.
statement
Hold
about
on.
Mr. Garrett's case?
Hold on a second, Mr. Garrett.
I believe I filed an amended information with, this morning,
Okay.
and that essentially we transferred what was a misdemeanor DUI into the third count in this information.
Okay, so does that mean there was like a CT number that doesn't?
There was, it was 24 CT 2977, I believe. Correct.
Okay, we'd still enter a plea of not guilty.
I just want to make sure if you've transferred that case, that he doesn't have to go to his next court date in the CT.
Right, he wouldn't have to. I believe it's been closed out, but it is a good idea.
Want to make sure. Did you have another court date on the DUI?
The ones
sir?
I got was February the 4th, and today and February the 4th.
Okay, so February 4th was your misdemeanor DUI date. They put that case into this one, so you don't have to do the February 4th date anymore. That case has already been closed.
Okay.
So you just have to do this court date now going forward, which again is going to be February 24th at 1:30.
Thanks, sir.
All right. All right, April Glenn. Oh, okay, case is null prost. 24 CF 2825. Donald Hanish. Mr. Williams, and this is your case.
Yes, sir. Judge, Mr. Hanish already has a case. We just did our notice of appearance on this, and in fact, the file was sent over yesterday afternoon. So I'm going to go ahead and plead not guilty on it, ask that it track with the other case.
Okay.
Judge.
All right, you're going to be on, you said he has another case. What is that case set for?
That's set for 2/24, Judge.
Why don't we put this, well, this one is listed for April 28th, but I'll just put it on 2/24 as well, so they can all run together.
That's fine, Judge.
All right, 2/24. Mr. Hanish, if he's still incarcerated, that'll actually be the 26th. They'll bring you over. Trying to spread everybody out a little bit more so we don't have these long days with everybody here till 7 o'clock.
Mr. Hanish, I'm going to give you a copy of the charging document in this case, and I'll come out to the jail and go over everything with you.
Thanks.
Okay?
All right, Robert Harrison. This is 24 CF 2838. Mr. Williams.
Yes, sir. Judge, Mr. Harrison likewise, I believe, has another case that's already set on the docket. I did check, and information was filed on this case. Let me ask that those two track. Let me see if I brought his other file with me. Looks like I did, Judge. It is set for 2/24.
All right, 2/24, Mr. Harrison. We'll see you back on that date.
Yes, sir.
All right, Mr. Harrison.
Thank you.
All right, sir.
That's the end of my 1:30 docket.
She changed this one.
Oh, here it is. Must have just got stopped. Oh, I've got it, okay.
Right.
All right, Sammy Johnson, I was gonna say, I guess it's just because it folded up. But that doesn't make sense, there's a lot of people here.
Who did the school? No.
But only.
No, you did it for that.
Okay, so we'll skip.
He's an older fellow, he's going to be kind of slow moving.
All right, Harvey Langley.
I got him right. I told you, remember there was one that that's the second defendant, don't worry about it.
Harvey Langley, 24 CF 2897. Mr. Williams.
Judge, I'm going to enter a plea of not guilty on Mr. Langley's behalf, 15 days for pre-arraignment motions. There you go, Harvey. And demand trial by jury.
February 24th.
Thank you, sir.
All right, thank you, Mr. Langley. We'll see you back. Mr. Langley, let's get moving. William Lawrence. Twenty-four CF 2858.
Come on up, Mr. Lawrence.
Mr. Lawrence, you are here charged with 2 counts of possession of a controlled substance, possession of drug paraphernalia. You don't have an attorney at this time. Do you want one?
Yes, sir.
Can you afford one?
No, sir.
All right, I'm going to appoint the public defender, but you're going to have to fill out that application and go file it downstairs in the first floor once you're done. Do that before you leave here today.
Yes, sir.
Here's the application. Judge, I'll enter a plea of not guilty on his behalf, 15 days pre-arraignment motions and trial by jury. Card, sir, you need to
I'll
call
make
and make an
contact with
appointment.
Thank you very much.
February 24th.
I'll come out and see you then. I'm sorry, Judge, what was the date you gave me?
February 24th.
Thank you.
Maybe 26th now. I'll rotate.
Here we roll.
All right. Kimberly Lehman, is she in custody? Oh, there she's coming up. Kenny, you're just blocking the way. I can't see around you.
I'm a big boy. My wife says my dad wasn't a glass maker, so.
All right, Ms. Lehman, you're here in 24 CF 2884, charged with possession of a controlled substance, possession of drug paraphernalia. Can you afford an attorney to represent you?
No, sir.
You want me to appoint you a public defender?
Yes, sir.
All right, I'll do so at this time, but you got to fill out that application. Go file it downstairs in the first floor before you leave today.
Offer, may I put the offer on the record, Judge?
Go ahead.
Judge, may I put
Go
the
ahead. Sorry, I guess I didn't say it.
The state would be offering a plea to a misdemeanor, adjudicate, and 270 in court costs, if she's inclined.
On a felony, it'd be a misdemeanor, so you wouldn't have any loss of civil rights. Judge,
We have you, I don't want you making a snap decision. I'll handle it today if you'd like, but just take a seat. We're going to handle some other cases, and we'll call you back up.
All right.
Because if we handle it today, we could potentially save you the public defender fee and all that. But I don't like the idea of someone making snap decisions about their rights like that. But I'll take it later today. All right. Michael Manning.
Information's not been filed, but I think it.
Arrested 115. All right, Mr. Manning, they put you on the rocket docket for us here. You just got arrested a couple weeks ago, right?
On the 15th.
All right, so an information hasn't been filed yet because it's been so quick. But can you afford a lawyer to represent you in this case?
No, I can't.
Okay. Do you want me to appoint you a public defender?
They already said they did that at first appearance, but I'm supposing they didn't.
I'm wondering if the paperwork just hasn't caught up because they probably put you on an arraignment date that was a little too quick because things just don't move this fast. What's our next arraignment date? Okay. February 6th, enough time?
Yes.
All right.
I also have a misdemeanor court date coming up. I'm trying to get all that into one.
Well, that's not how it works. I mean, unless it's from the same incident.
It's the same arrest.
Well,
It was a misdemeanor warrant and what you have here today.
yeah, they're probably going to keep that separate still. Let me see what they've got. Although you were arrested for both at the same time, they didn't occur at the same time.
No.
So it looks like you've still got 25 MM 127 for which you've got court on the 4th. I'm going to bring you back to us on the 6th, so those are both next week.
Okay.
I've appointed a public defender for you, but we're going to have you come back for arraignment next time to see if the state's filed information, because, again, the paperwork just hasn't moved as fast as we'd probably like it, because they set you for a really quick court date.
Okay, so I'm coming back on the 6th, and I'm
Coming back on the 6th.
scheduled a public defender, all right.
At 1:30.
Yep.
McDonald we had, right? All right, Stephen Moore.
Did you call Stephen Moore?
Oh, nope, that's far enough.
Judge, did you?
Say again?
First name Stephen Moore?
Yes. 24 CF 2937. Looks like Mr. Williams, public defender, has been appointed.
Judge, the only, is your last name Moore, sir? M-O-O-R?
Yes, sir.
E? Judge, I'm sorry, the only one that I had that I was aware of was Jeffrey Keith Sasser. Has an information been filed in this gentleman's case? Okay, and we are appointed, Judge?
That says Jay Williams next to it.
All right. Judge, I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions, and demand trial by jury unless the state's got an offer.
Possession, paraphernalia, get DUI, and marijuana.
If you withhold in the felony counts, single felony count, 3 years probation with a substance abuse class, and then there would be all the lawful DUI terms that we would ask for him to do it in that as well.
Will that offer still be on the table at pre-trial conferences?
It will.
Let me take some time to talk with him about it, then have him come into the office.
It will, yeah, we can do that.
Since there's a DUI involved.
It looks like there's maybe a 2001 prior DUI that we'll be ordering. But if it gets to that point, I'll let you know before I revoke that offer.
All right, but that would be from 2001.
It would be outside of 5 years, yes.
All right, sir. So if you wanted to take the probation, you could do that today, but what I would suggest to you is that you come into the office and meet with me, and we talk about what your rights are, find out what evidence they have against you. One of the charges is the DUI, and those can be relatively serious.
Yes, sir, I'm aware of that.
Okay. All right, so Judge, I'll stick with my original entry of a plea of not guilty for him, and if we can just get a date on it.
It's set for April 28th. That will be 1:30.
Thank you, sir.
All right, James Mullen. 24 CF 2918. Mr. Williams, you were appointed to that case as well.
Yes, sir. Yeah, just take both of them. All right. Mr. Mullen, come on up. Yeah, go this way, sir.
24 CF 2918.
Yes, sir. Judge, I met with Mr. Mullen previously. I'm going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions, and to be in trial by jury.
All right, February 24th, 1:30. We'll see you back on that date, Mr. Mullen.
I'm sorry, Judge, what was that date again?
2/24, 1:30.
Thank you. Now, since you're out, sir, that's actually going to be 2/26.
No,
No,
2/26 is the jail date. It's the afternoon, though, 1:30 on 2/24.
All right, Mr. Mullins, I'll give you a call and talk to you. Call the office and make sure we got a number for you.
All right, Sarah Munda, 24 CF 2820. Mr. Williams, public defender's been appointed.
Let's see if I've got information from this. There we go. Ms. Munda, I really need to see you. You need to come in the office and talk with me, okay?
Okay.
Judge, I'm going to enter a plea of not guilty on her behalf, request 15 days for pre-arraignment motions, and to be in trial by jury.
All right, February 24th, 1:30.
Thank you, sir. Okay? You just schedule an appointment, you're almost never going to actually catch me there, usually at the jail or in court. So, but I have a day set aside for appointments.
All right, Anthony Nitsky,
Judge, I believe Mr. Nitsky is incarcerated.
he's right behind you. 24 CF 293.
Yeah, come stand over here, Mr. Nitsky. Okay, Judge, I'm again going to enter a plea of not guilty on Mr. Nitsky. Mr. Nitsky, I've got your information. Did you ever? All right, so Judge, we can get a date on him.
All right, 2/24 at 1:30, unless you continue to be incarcerated, Mr. Nitsky, then I'll be on the February 26th.
Thank you, Judge. All right, sir.
All right, Tyson Odom. (24 CF 2948). Miss Rivers, I think this one's assigned to you. Miss Rivers.
Yes, sir.
I think this is you. Tyson Odom.
Thank you. Your Honor, Tyson Odom before the court on 24 CF 2948. We're going to enter a not guilty plea, request trial by jury. 224 docket.
This is 428.
428, okay.
All right, so April 28th at 1:30, Mr. Odom.
And in the meantime, please call me so we can go over your case.
Yes, ma'am.
Okay?
Thank you, Judge.
You're welcome. Terrence Parker.
That's going to be Jennifer Flowers. That's Jennifer Flowers.
She not here?
Oh, because this is... This would be Miss Flowers. Okay, Your Honor.
Clerk is telling us that she may have conflicted off his other cases already, so.
Marty Nopes for something.
Jason Cobb, I think, is assigned.
That's what my wife had said when she looked on it. It said Jason Cobb.
Yes. So what I'm gonna do is I'm gonna allow RCC to withdraw, and I'm gonna appoint Jason Cobb, so you've got one lawyer who's gonna handle everything. Or already set for 2/24. So we'll have you come back on February 24th, Mr. Cobb.
Okay.
For all your cases. All right, thank you, Mr. Parker. All right, Adam Richardson. 24 CF 2847. Mr. Richardson, you're here charged with resisting an officer with violence, battery on an officer, and domestic violence battery. Do you understand all those charges?
Yes, Your Honor.
Can you afford an attorney to represent you?
No, Your Honor.
All right, I'm going to appoint the public defender's office for you. But
Your
you're going to
Honor.
have to fill out that application, go turn that in, but fill it out, turn it in downstairs on the first floor.
Your Honor, I'm gonna enter a not guilty plea on his behalf, request trial by jury, court date of 2/24.
2/24 at 1:30.
2/24, 1:30.
Call my
Make
office,
sure you
okay?
fill that out and turn it in downstairs before you leave, Mr. Richardson. All right, Ashley Roberts.
Your Honor, Ms. Roberts is present and approaching, 24 CF 2909. Your Honor, we're going to enter a not guilty plea, request trial by jury,
Okay.
ask for the 2/24 court date.
All right, Ms. Roberts, come back February 24th at 1:30. Make sure you stay in touch with Ms. Rivers and make an appointment with her office.
Mm-hmm.
All right, I think we have Ethan Smith. Is that one you're going to bring back?
Yes, Your Honor, and I am ready. I presented the state with the plea agreement, and
We'll bring
Okay.
it back up once he's ready. All right. Shannon Smith.
Shannon Smith.
Shannon Smith is Mr. Gilbert, 2/24 at 9. Hunter Stewart. You have Hunter Stewart back there, Steve? All right, 24 CF 2889, Ms. Rivers.
Your Honor, I believe we're going to be able to work this out. The state has made an offer this morning. I just need to,
I love how y'all still think it's the morning. I've done it too, so it's okay.
if I could just convey it
If
to
I
you.
can get out of
real-
here before the sun goes down, I think we'd all be pretty happy. I think we're going pretty well.
Yeah, and I'll come out and talk to you on the other. All right, so you're gonna need to sign it right there. Okay.
Mr. Stewart, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name, date of birth?
Hunter Stewart, December 8th, 2002.
All right, you can put your hand down. All right, I've been handed a plea form in 24 CF 2889 where you're charged with 2 counts of possession of a controlled substance, which are third-degree felonies, punishable up to 5 years in state prison. Do you understand that? All right, this calls for you to plead to a lesser included on both of, I'm assuming that's paraphernalia? Okay. Which would be an adjudication and several different costs. Is that what you want to do today?
Yes, sir.
Yes?
sir. Yes,
Okay.
sir.
Have you had enough time to go over this with Ms. Rivers, your attorney? She answered all your questions? Did you go over the document and understand it? Did you sign it? Okay. And are you satisfied with her advice and representation? Anyone force or pressure you to threaten you to sign this? Anyone promise you to anything to sign this? Are you under the influence of anything at this time? You got any mental health issues or concerns? Do you understand there won't be a trial of any kind and you'd be giving up all of your trial rights that are listed in this agreement? Okay. And you understand you're waiving any potential defenses that you may have? Okay, and what is your plea? All right, the court's going to accept your no contest plea in 24 CF 2889 as freely, voluntarily, knowingly given. It's going to be the lesser included of possession of drug paraphernalia, first-degree misdemeanor for each count. Adjudication, $270 in court costs, $50 in cost of prosecution, $50 PD fee, $50 application fee. I'm going to give you 90 days to pay those or set up a payment plan with the clerk's office. Do you understand all that? Okay. All right, you have 30 days to appeal the judgment and sentence of the court. All right, thank you, Mr. Stewart. Dustin Strawn. Anything on Mr. Strawn? Ew. About to have a pair. 24 CF 2849.
What's the KPS judge?
Just check to make sure he got the right date. That's my last thing to look at. All right, be KPS no bond on Mr. Strawn. All right, Suttles we handled.
Yes, sir.
Okay. Cordell Thomas. 24 CF 2845, Ms. Rivers.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
Okay, it's going to be 224, or if you're still incarcerated, Mr. Thomas, I'll bring you
Sir.
back on 226.
That'll be 226, Your Honor.
Okay. Next is Kevin Wilkes.
Okay, yes, ma'am.
Twenty-four CF 2906, Ms. Rivers.
Your Honor, I would enter a not guilty plea at this time, request trial by jury.
224 at 1:30.
Yes.
All right, is
Okay.
there anybody on the 1:30 arraignment docket who hasn't been called? You've got okay, the females? Tell me who you've got.
Sammy Johnson is right here.
Who's that? Sammy Johnson. All right, Sammy Johnson, 24 CF 2846. That's Mr. Williams'
I
case.
believe so, Your Honor, because we do have a written plea agreement.
All right, can we bring Mr. Johnson back in a little bit? Your lawyer's speaking to another client, so we're going to call you back in a little bit. All right. You ready on that one, Ms. Rivers?
Yes, Your Honor. I just need the state. The agreement. Your Honor, if we can just have a moment to sign it. All right.
13 months time served
Yep.
on all my charges?
13.2 months, DOC, and it's, see, credit for time served, you get credit for time served. It.
How much can you tell me, like, how much is 13?
I know of.
Well,
Oh, okay. So you know more than me. May I, no, he's got to ask you
yes,
questions.
yes, ma'am.
I may approach you.
All right, Mr. Smith, can I get you to raise your right hand, please? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, we're here in 24 CF 2817 and 25 CF 26. I've been handed a plea and sentencing agreement. Did you go over this with Ms. Rivers?
Yes, sir.
Did you understand it all?
Yes, sir.
Did you sign it?
Yes, sir.
All right, and it calls for 13.2 months in Department of Corrections. Do you understand that?
Yes, sir.
That's what you want to do today?
Yes, sir.
Did Ms. Rivers answer all your questions?
Yes, sir.
You satisfied with her advice and representation?
Yes, sir.
All right, in the 2817 case, you're charged with possession of a controlled substance, third-degree felony, punished by up to 5 years, and resisting without, which is a 1-year misdemeanor. 25 CF is fraudulent use of credit card and petty theft. Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Any mental health issues or concerns?
No, sir.
Anyone force, pressure, threaten you in order to get you to take this plea?
No, sir.
Anyone promise you anything in return for the plea?
No, sir.
You understand that by entering a plea, you're giving up your right to a trial and all the trial rights that are listed on the first page here?
Yes, sir.
All right. Do you understand you're waiving all potential defenses that you may have?
Yes, sir.
All right. State's agreement is 13.2.
It is.
All right. What's your plea, Mr. Smith?
No contest.
No contest.
All right. I'll accept your no contest plea in both cases, all counts. It's freely, voluntarily, knowingly given in 24 CF 2817. Count 1, 13.2 months DOC. Count 2, 11 months, 29 days concurrent OCJ, or Okaloosa County Jail. 25 CF 26. Count 1 is the fraudulent use of credit cards, 13.2 months concurrent DOC with the other case, as well as petty theft will be credit for time served. There'll also be, let's see, in 24 CF 2817, $515 in court costs, $100 PD fee, $100 cost of prosecution, $50 public defender application fee. 25 CF 26, $415, $100, and $100.
And Your Honor, he just wanted to make sure for the record that he would get credit for the time he's been in so far.
Of course, he'll get credit for any time that he has earned. It wasn't checked here, but adjudication of guilt, correct?
Yes, Your Honor.
On all counts. And I believe this is a guideline sentence, correct?
It is, Your Honor.
Okay. All right. Any questions, Mr. Smith?
No, no, sir.
All right, thank you, sir. You have 30 days to appeal the judgment and sentence of the court. You got to be fingerprinted before you go.
And Your Honor, I have a hearing with him in front of Judge Ward, so if they could just not, okay, that would be great.
Okay. Johnson, you mean?
Yes, sir.
This is Holly Fowler? Yes. Okay. Charles Russell, Public Defender's Office. This is Ms. Fowler. Case number is 24 CF 2628. State has filed an information. This time we're going to enter a plea of not guilty. Request trial by jury, 15 days for any pre-arraignment motions, and ask for the pretrial conference date.
All right, Ms. Fowler, your pretrial conference date is going to be February 24th at 1:30 if you're released before then. Otherwise, it'll be February 26th.
Okay.
I'll come out and see you.
Williams, are you ready for Sammy Johnson?
Stephen Johnson?
Sammy Johnson.
Sammy Johnson, I'm having her look at the score sheet. But other than that, yes, sir, I'm ready. Hey, come on out, Mr. Johnson. Okay. Come stand over here. Okay?
Right here.
Yes, sir. Right here.
Face the judge.
Turn around and face this way.
Thank you. All right, Mr. Johnson, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. You're here in 24 CF 2846, charged with one count of failure to register. Do you understand that charge?
Yes, sir.
Okay, and did you go over this plea and sentencing agreement with your attorney, Mr. Williams?
Yes, sir.
Did you understand it?
Yes, sir.
Did he explain everything to you?
No, sir.
Say again.
Oh, did he explain?
Did he explain things to you?
Oh, yes, sir.
Did he answer any questions that you had?
If I had one, he did.
Okay. And did you sign the agreement? Okay. Are you under the influence of any alcohol, drugs, or controlled substances?
Do what?
Are you under the influence of any alcohol, drugs, or controlled substances?
Oh, I don't do drugs.
Okay, so you're not under the influence of anything, including prescription medicines right now?
I don't know what's in diabetic pill. There ain't no drugs in it.
Okay, but you understand what you're doing here today,
Yes.
right? Okay. Anyone promise you anything in return for you doing this plea?
No, sir.
Anyone force, pressure, or threaten you in any way to get you to sign this plea?
No, sir.
You understand that all right, Mr. Johnson, do you understand that by entering this plea, you're giving up your right to a trial?
Yes, sir.
Do you understand you're giving up all your trial rights, which are listed here on the first and second
Yes,
pages
sir.
of this agreement?
Yes.
Do you have any questions about those?
No, sir.
Okay. All right. If you could tell her I said I don't want to hear it another word. It's not going to help.
Can we all,
Let's finish this then, and then I'll handle that. But
I may be able to provide an explanation.
that's fine. I understand. But I got to be able to hear, and I can't have someone screaming in the next room the entire time I'm trying to talk to Mr. Johnson. All right, Mr. Johnson, do you understand that you waived any potential defenses that you may have to this charge?
Yes, I understand.
Okay, and did you understand the terms of the agreement, which is the community control and probation?
Yes, sir.
Okay, and what is your plea?
No
I
contest.
plead no contest.
All right, Mr. Johnson, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 1 year of community control, followed by 1 year of probation. You're going to have to wear a GPS monitor at the cost of $1 per day, $515 in court costs, $150 PD fees. Cost of supervision's been waived. If I didn't say so, adjudication of guilt. And this appears to be a significant downward departure. Is that right, State?
It is, Your Honor, based on the totality of circumstances.
Okay. All right, Mr. Johnson, you have 30 days to appeal the judgment and sentence of this court, and I need you to be fingerprinted before you leave today, but you're also going to have to talk to probation behind you first.
Yes, sir.
Thank you, sir.
Okay. Thank you, sir.
And Your Honor, he's to remain in custody until GPS is attached.
Until the GPS is actually attached, yes, sir. So I found this is a downward departure. All right, who do we have next? That. Okay.
Oh, full black mold, y'all are ashamed of yourselves.
Judge,
Excuse me.
the state has tendered an offer for probation for Ms. Heglin, but under all the circumstances, I think it's best that I spend a little bit more time with her.
Okay.
As well as perhaps
I'll take
inquire the
papers.
services of an expert.
I'm sorry.
If she wants to represent herself,
Yeah, I would love to have probation. It will keep me sober and,
All right, but I think what I need is for Mr. Williams to explain this to you.
ma'am,
Mr. Williams?
what my concern is with the outbursts and the different accents. Let me just ask, are you like having any kind of psychiatric symptoms, hearing voices from people that
I will
aren't
be able
there,
to handle
anything
at
like
Fort
that?
Walton Beach Hospital.
Okay. Do you want me to have you evaluated to make sure that you're
Not
competent?
in this facility.
Okay.
I'm disgusted.
Well, let me ask you, do you understand that what you're charged with is possession of methamphetamine, a third-degree
Trash.
felony?
Ma'am, let him finish his questions.
And violation of a domestic violence injunction, which is a first-degree misdemeanor. The statutory maximum for those would be 5 years on the possession of meth and 1 year on the DVI. That's not what you're looking at. What the state's offer is to adjudicate you guilty, put you on probation for 3 years. They would waive cost supervision, but they do that in all public defender cases.
Thank you for calling me a good mother.
$615 in court costs. Get an evaluation to see if there's a substance abuse problem, and if so, follow any recommended treatment. Random urinalysis, of course, no controlled substances without a prescription, and to not trespass at 3141 Winstead Court in Crestview, and also to abide by the injunction. Total of $150 public defender fees, and on the domestic violence injunction, years probation running concurrent. You know, of course, I'm not actually your dad, right? Okay.
What did she say?
Well, Judge, I don't.
Nothing.
I think it was meant in jest, and I was just confirming that it was. So,
I want to be a sheriff one day. Sorry.
do you, have you ever been under the care of a psychologist or anything like that?
My mother never got me mental health. Ever. Ever.
Okay, and are you hearing any voices, seeing?
Sir.
Other than like my voice and the court's voice and, you know, stuff where you can see a person associated with it?
When I get to Fort Walton Beach Medical Center, I will handle that.
It's my understanding she recently entered a plea in another case where Ms. Flowers represented her.
Honey, I don't even remember yesterday.
My concern, Ms. Hagelin, is that you don't quite know what's going on here today.
And that's because of Sergeant Burgess.
Okay. So what I'm going to do is, Mr. Williams, you want to bring her back next week to see if you can talk to her and see if a motion is necessary?
I would love to just get on probation for a year. Can we do that instead?
I'm not sure you understand what's going on here today, Ms. Hagelin.
I have no idea.
Due to your repeated outbursts in the hallway where I had to stop court twice, so my deputy could tell you to keep it down.
Forgive me, they fed us a human inside of the jail. I'm not playing. I have the evidence in my room.
Okay.
On that, Judge, let's, I don't know that I'm going to be able to resolve that question within a week. Normally what we would do is we would, let me ask you, if I send somebody out to evaluate you, will you go ahead and talk with them?
No.
Okay. In that case, a motion would be necessary.
Okay. All right, so we want to put it on the 24th? I'll put it on next week if you think anything can be done.
Let's try for next week. Sometimes we're looking for lucid moments.
Okay. All right. February 6th, we'll come back. I want to make sure they can come talk to you, Ms. Hagelin. Make sure you understand what's going on here today. But when you come back next time, I don't want the outburst. Is that okay?
All right, well, forgive me.
All right. Thank you. We'll see you next week.
You leave my kids alone.
I have nothing, I
understand.
Judge, we've had this lady sitting out here in the gallery, and she's going to accept the state's offer, and I'm going to ask that the court unappoint us.
Yeah, that's fine. I just wanted her to take a quick look at it and think about it. And
Is that Ms. Lehman?
Yes, ma'am, it is. Yes, we can bring Judy back.
Come on up, ma'am. All right, this is Kimberly Lehman, 24 CF 2884. I think it was a plea to just the paraphernalia, is that right?
That's correct.
Okay. Ms. Lehman, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Did we have a written agreement, or are we just announcing the terms?
No, I didn't write one, Judge. It would be, the state would dismiss count one, the third degree felony, in exchange for a plea to count two, the possession of paraphernalia, adjudication of guilt, and $270 in court costs.
Okay. Do you have any prior record, Ms. Lehman?
Yes, I do.
Okay. Do you have any prior adjudications of guilt?
I believe so.
Okay, I just want to make sure, because there's some other issues that may go along with it, and since you don't have an attorney explain it to you, I want to make sure that I've asked you that question. All right, so they're asking for an adjudication of guilt, which means you can't seal or expunge or anything in this case, and potentially any others, and $270 in court costs, and that was it, Ms. Turner?
Yes, sir.
Okay. Is that what you want to do today?
Yes, sir.
All right. Do you feel comfortable going through with this without a lawyer present?
Yes, sir.
Do you understand the advantages of having a lawyer?
Yes, sir.
They understand the rules and all those things?
Yes, sir.
Do you still feel comfortable?
Mm-hmm.
Okay. Are you under the influence of any alcohol, drugs, or controlled
No, sir.
substances? Do you have any mental health issues or concerns?
No, sir.
Has anyone forced, pressure, or threatened you in any way to take this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that by entering a plea, you're giving up your right to a trial.
Yes, sir.
And by giving up your right to a trial, you're giving up your trial rights, which include the right to cross-examine and confront witnesses against you, call your own witnesses, testify on your own behalf, or remain silent, which is your option and your right. You understand
Yes,
those
sir.
things? You understand that there won't be a trial of any kind if you accept this plea?
Yes, sir.
Okay. And what is your plea? Guilty, no contest, or not guilty?
No contest.
Okay. I'm going to accept your no contest plea to count 2, which is the possession of drug paraphernalia or narcotic equipment, the first-degree felony or first-degree misdemeanor, $270 in court costs. Do you need some time to pay that?
Yes, sir.
I'm going to give you either 30 days to pay it or go set up a payment plan. Okay, before those 30 days are up. Otherwise, you may have some issues.
Okay, thank you.
Okay, any questions? All right, thank you, ma'am. You have 30 days to appeal the judgment and sentence of the court. All right, who else do you have?
Judge, we can bring Mr. Judy back. The court had passed this for me to sit down and try to calculate myself his credit, and I have done that. All right, so what I've got is he's got 2 cases in 2053. He's got the most credit. He was, I can go through the arrests and the bond dates, but it doesn't matter in the beginning because there's a credit memoranda that was entered into the record on 4/21/2020 showing 209 days credit as of his 4/21/20 sentence. He was then rearrested in our jail on 10/21, but he had had a hold from this county in the county that was the original county since 8/29, and the state and I had negotiated that he would get credit from that 8/29 date. So that 209 days plus the 154 from 8/29 to today is 363 days credit. So that's the credit he has in case number 19-2053. Now, in case number 19-3152, he was actually arrested on that date on November 18th. So he doesn't have the same amount of credit on it from November 18 of 2019 to his sentencing on April 21st of 2020. He had 155 days. And then from the 8/29 date to today's date again is 154. 155 plus 154, I get 309. I just wrote in this credit on it.
Well, that was. I had not reviewed the credit. I'm not in a position to stipulate the credit.
Okay.
If our memories differ, then
What's the offer?
Guideline sentence.
I want to bring him back next week since he's not going to get to 15 months by next weekend.
That's fine with me, Judge.
Enough time to look at it, Ms. Turner?
Yes,
Okay.
please.
You want to just, I'll tell you what.
Ms. Judy, Mr. Judy, we obviously want you to get all the right amount of credit, but it's kind of hard to sometimes do that on the fly, and even then, typically the jail determines that or DOC determines that.
Okay.
We'll just bring you back next week on Thursday. That's February 6th at 9 o'clock. Give them time to get their calculators out and figure this out for you.
All right, sir.
All right, we'll see you back next time. Okay.
I'll give you a better, more legible breakdown.
All right.
I'll send it to you by email.
Does anybody
Maybe that'll
who's
help.
in the audience think they had a 1:30 docket case? So is everyone here for something at 2:30? 2:34. Y'all mind if we take about a 5-minute break? All right. Okay. Okay, maybe. Well, I understand, but this is a team atmosphere, right? All right, let's take about a 5 to 10 minute break.
All rise, please.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Terrell? Mr. Keach, you could swing around that monitor so I can see him. Well, he's fine. Just move the monitor up. Yeah,
Sorry about that.
Go ahead and announce everything, Mr. Keach, as far as the case.
Your Honor, this is State of Florida versus James Terrell. 2 cases on docket, 21 CF 924 and 21 CF 1577. We are here on a status update as it relates to Mr. Terrell's issue of competency. As the court recalls, when we were here last month, I believe, the issue was placement based on the indications in the report. After conferring with the state and also personnel at the Okaloosa County Jail, in addition to the previous mental health experts that rendered the reports, I believe the appropriate placement would be that he be placed to receive competency restoration services on a community-based placement at Bridgeway Center, and that he would be released to pretrial services with the special condition that he have a GPS or ankle monitor attached, and that he have no contact with any minors while out released on pretrial services. So that's what we're going to be requesting the court to issue, and that Mr. Terrell make contact with Bridgeway within 7 to 10 days of rendition of the order or of his release, but obviously we'll have to defer to the court on what it believes the appropriate time frame is. And just to perfect the record, Mr. Terrell's wife, Glenda Terrell, I'm going to ask you to stand, ma'am. She is present, and if the court needs to place her under oath, she's willing, ready, and able, but she has indicated to both me and the state that she is ready, willing, and able to assure that she can transport Mr. Terrell to and from his competency restoration services, as well as can provide him with a residence, obviously. And so if the court has any questions for her, you can call her as a witness.
All right. Come on, Mr. Terrell, you want to come on up?
Where, you want her at this podium or at
I'll
that?
have her just go with that one. That way there's 2 microphones. All right, Mr. Terrell, can you raise your right hand to be sworn? Do you swear or affirm that any testimony you give here today will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead, Mr. Keach, if you have any particular questions you want her to address. You kind of told me what she's going to tell me, but go ahead and ask her the questions.
Ms. Terrell, can you assert to the court that you have a vehicle that can provide transportation for James Terrell to ensure that he can make it to and from his appointments with any services as it relates to his competency restoration?
Absolutely.
Okay. And do you have a residence where no minors reside where Mr. Terrell could stay if he's released to pretrial services?
Absolutely.
All right.
Any other questions?
Do any
Can I see him?
Say again?
Can I walk over there and see him a second?
Not right. Not right. We got to figure this part out first, ma'am, and then we'll
Just
talk
answer
about
the
this.
question.
I'm just nervous, sir. I'm
I
sorry.
understand. It's okay. We've got plenty of time, and I think everyone's pretty much on the same page at this point. Do any minors frequent your home?
I'm sorry?
Do any minors frequent your home for any reason?
Once in a while.
Okay. Do you understand that part of
He
his
can't be around them.
He can't be around any minors. Do you have anything like a bus stop or a school nearby?
No.
Okay. Where's the closest school to y'all?
Let's see, we live up by Ace Hardware in that area.
Okay.
And I think the closest one would be high school?
All right.
Mm-hmm.
All right. State have any concerns or questions for Mrs. Terrell?
Our only question would be is if she is willing to agree with the court that she will make sure that he gets his
provide that support. I know she's not obligated to. Let's state to the court that she will get.
Ms. Terrell?
Absolutely.
Okay, so let me just explain that, Ms. Terrell. I can't hold you to that. You know, you're not a party to a case. I don't have any jurisdiction over you. However, if he can't make these appointments, then I'm going to ask him or order him to do, because you're not able to do it or you decide you don't want to do it anymore, it's going to tie my hands as to what's going to happen after that.
To be able to have him home and help him, I would do whatever I need to do, Your Honor.
Well, I understand, but the big thing is sometimes it takes a little bit of a village too. You know, you're not used to this yet, right?
I know.
So, and so it may take more help than you're able to give sometimes. So
And I do have some help at home.
Okay.
Too, so it's not just me.
And who's that?
It's my friend, it's Jim's friend, actually, Tim.
Okay.
He's with me now.
Jim and Tim.
And then I have a son that's 56 that lives there. He just got over cancer treatment, but he's staying with me to help me too, so he's there.
Okay. Anything else, Ms. Basso, from as far as the state? All right. So I've read, Mr. Barry, do you have something you want to bring up?
I don't know if this is my part to step in, but when she said he lives up there near Ace Hardware, right behind Ace Hardware is Northwood Elementary School.
We live across the street from Ace Hardware. I was just talking about the Ace Hardware area.
Okay. So
we live back in the old section of town.
Okay. So
it's not on the same side, no.
Okay. Saying on the other side.
I'd heard her say it, and I thought.
I appreciate you, Mr. Barry. You're certainly more familiar with Crestview geography and shopping centers than me, so I always appreciate the extra help. So I've read both evaluations, both by Dr. McDonald and by Dr. Harper. Obviously, they're a little bit different, and I think some of that has to do with the difference in time that they were done. However, it's pretty clear from everything I've seen in the file and read that Mr. Terrell isn't going to get to a point where we can finish up our case where he's at. Now, this is not any sort of commentary on what the case is, how it started, or what got us here, but obviously he's been incarcerated for quite some time. I've read, I think Dr. Harper's report is the more recent one where it talks about his health concerns, and I don't think where he's at is going to get us any closer to a close of our case. That has to be my primary concern. It's a situation where he was previously ordered to go to the state hospital. DCF says doesn't meet that criteria. And that criteria is based on whether or not they think he's a danger to himself or others, or really to others. Correct, Mr. Keach?
Correct.
So, part of the decision I have to make is based on the determination that they've made, but also what was put in the reports initially. And again, some of those things he's unfortunately regressed since those dates. So as much as he wasn't considered a threat at that time, it would be even more so at this point.
I will take care of him. I will make sure nothing like that happens.
So,
nobody comes around, I will.
What I'm willing to do at this time, with regularly being updated, is to release him to pretrial supervision. I don't know if that's going to be able to happen today because they have to be involved. That's a different group of people who are not here today. He's going to have a GPS monitor to make sure we know where he's at. You're going to have to help, I'm sure, with that, Ms. Terrell, as far as making sure it remains charged and that it keeps it on. And if there's ever any concerns with, he doesn't know quite what it is and wants to take it off, there could be some concerns. But pretrial supervision will help y'all through that process. But he's going to have to start his counseling as soon as possible. So Mr. Keach is going to draft an order kind of explaining all this.
Okay.
The state's going to have a chance to take a look at it. Then ultimately I'll revise it if I feel the need to, and then that will get signed within a week, 7 days. He's going to have to get that ball rolling.
Okay.
I'm sure that's going to take some involvement from you as well. But
Okay.
again,
Fine.
because you're willing to take this on, if it doesn't get done, he's the only person I can really do anything with.
It'll get done.
I understand. I'm just trying to make sure we're all clear
promise.
as to what the situation is. I'm not making, when I say things, when I say them repeated, it's not because I don't think it's going to happen. I just like to make sure people are doubly sure or triply sure what is intended here. I can't say, I'm not a mental health expert. I can't say on how things are going to go. Will the counseling work? That's for the experts to figure out and then ultimately give an opinion and tell me, and I'll make the decision. But we're going to have to see how it goes. All right. So he's going to have to do that and stay diligent with it, with your help and the help of other family members. But part of his release will be, again, it's hard for me to say no contact with any minors, because if you're going through the grocery store, a child could come by, but it's no unsupervised contact with any minors. So he can't be in a situation where he's alone with any minor child.
That's correct. And I don't think he'll be going to the grocery store anyway, the condition he's in.
I always just say grocery store because that's kind of the common thing that most of us do.
Yeah, yes.
But if he's ever in a place, he has to be in that where children are, he has to be supervised by a responsible adult.
Yes,
so
sir.
that he's not having any sort of unsupervised contact with him in
Right.
any way. And I understand the situation, but hopefully this will lead him to be in a better place.
It's going to be.
So, any other concerns from the state? Okay, Mr. Keach.
None by the defense. I guess the only other question, is he being released pending the order, or does the court want the order to pretrial services, or does
How
the court?
quickly can you get me an order?
I think I could get it to you by I will try to have it to you by close of business tomorrow.
Okay.
If that's okay with the state.
Okay. So, get me the order as soon as possible. Send it directly to my assistant. If it goes through the portal, we may not see it right away. Sometimes there are some concerns that way. Send it directly to my assistant, Ms. Guzman, and I'll get it signed as soon as I know. Make sure when you put it through, high importance, flag it. We need to get this signed as soon as possible. But also make sure that Ms. Bastos had a chance to take a look at it first.
And I'll go ahead and respond directly also to Ms. Guzman. I've seen it, and that she can relay that to.
Okay, and I'll do my best. Obviously, pretrial, they do things on the weekend too, but probably not this. So we hope to have it done by the end of business tomorrow. I'll make sure I'll get it signed as soon as I have it, but it could be Monday.
Monday.
I'm not saying that's when it's going to be, but it could be. Well, I understand, ma'am, but you are on a pretty long journey that I'm just getting on board. And I want to do what I can, and I think everyone's on the same page here. But things have to be done the right way to make sure they're clear.
I'm just anxious.
I'm sure you are.
I haven't seen him in 3 years and 7 months. This is my first time to get to see him.
Okay, well, he's been
Because I've seen him on the videos, but not in person. Because we don't have visitation in the jail. There's no visitation.
I understand.
And I begged them.
Well,
Jeremy there to let me get me in to
Mr.
see
Keach
him.
can't change that. The jail has, there are rules that the jail has that I can't do anything about. It's just, we all have our own roles and we have to stay within our lanes.
Doesn't hurt to keep asking them, Mr.
So I'll get it signed as soon as I get my hands on it, and if I have to revise it at all, but I can't imagine if I get it on even end of business on Friday that I won't have it signed and ready to go by Monday.
Okay. That sounds good. Someone's going to let me know?
I will let you know. I'll either call you or email you once it's in motion. Okay?
Okay. Can I go over there and look at him now?
I can't let you make any contact with him at this point. Okay. That's a rule for everybody.
But you're going to see him in a few days, so
Well, I should let him know I'm here.
Okay. As long as there's no physical contact, do you?
What if I don't touch him? Yeah.
Sure. Come here. I'll rotate him and I'll.
I'm going to take you home.
All right, thank you all.
Your Honor, from really speaking on behalf of pretrial release here and hoping he doesn't violate any city ordinance, since he has not been sentenced and is just on a release plan, is he going to have to conform to the city ordinance of you can't live within so many feet of a school, daycare, bus stop, any of that?
I mean,
Since he has not been sentenced? Okay.
Okay.
Okay, I just want to make sure that we weren't right back here.
I'm not aware of what city ordinance there is, but.
Did I go sit down?
You can-
Lunch up.
you can sit down. A city ordinance? Well, we didn't even talk about if he's in the city limits or not. I guess I wasn't really thinking.
I'm going to get her address and try to help her. Is that fair?
All right, and again, if anything comes up, we'll work on it. Okay. Thank you, Mr.
Thank you,
Keith.
Judge, and thank you for taking the time to read all that stuff and deep dive into it. Yeah, we appreciate it.
That's the only way to get to the bottom is to dive straight through the top, so.
Thank you.
All right. All right, any particular order y'all want to call anything else?
No, I'm not going to do that anymore. Yep, that works. Oh, that's cool. Okay. Your Honor, I had filed a motion to dismiss count 1 based on the corpus delicti argument.
This is the 24 CF 2231.
Yes, Your Honor. I believe the state is going to concede. We are actively talking about a possible resolution, and I would just ask that we continue this to the regular February 26th date.
Yes, Your Honor. I'm conceding the count.
Count 1, which is the possession with intent. Okay,
That
there's
is
still the
not- yes.
possession charge, there's just no possession with
No,
intent.
no. 1 second, Your Honor. That's
Because count 2 is possession.
right. The count 1 will be dismissed, so only will be left with count 2. Yep.
And 3.
On that one, yes.
Right. So you're conceding to the motion to dismiss as to count 1?
Yes, Your Honor.
Okay. All right, so in 24 CF 2231, based on the state's conceding to the defense motion, count 1, which is the possession with intent, will be dismissed based on a corpus delicti argument where the only evidence of that was what he said, and there was no corroborating
Correct.
evidence as to his intent to sell anything. Okay. All right, then we want to put this back on the February 26th date.
Yes, Your
At
Honor.
9 o'clock and see if y'all can get it resolved.
Yes, Your Honor.
Okay.
Okay. Thank you. I'll be back out once I get you some more information.
All right, then we have Mr. Tatum.
Yes, Your Honor. And Your Honor, some things have come up, so I do need to, if I could, speak with Mr. Tatum momentarily. Yes.
Yeah, it's fine.
I mean, the state's going to announce it, but I was going to tell him
Okay,
as
go
well.
ahead.
Yes, Your Honor. We were going to have 1 second. A VOP evidentiary hearing. However, last night around 8 p.m., the officer that was subpoenaed to come for the hearing informed me that there was an additional video that is very material in this case that I didn't have. So he's sending it. He should be sending it today to us, and we will share it with the defense as soon as we get it. And it's the interview of the defendant where he makes some admissions, and that's the reason why it's material.
I could talk to him, but the video ain't got nothing on there. The police just asked me a question. What?
attach the statute where it shows that she can do it based on that conviction right there. So that means your lowest possible sentence is. No. Your Honor, my client has indicated that he didn't wish to continue the hearing. I did indicate to him that, we would need to watch this video, but he wants to go forward. The state has provided a new score sheet charging him as a habitual violent felony offender special concern on the points, which elevate the minimum score to 53 months DOC. And I'm just now telling him this because, we just got it. Still want to go forward?
Yeah, I ain't did nothing wrong, man. How can you, these charges is really, I'm on probation for something that supposed to get thrown out. Only reason I took probation, Your Honor, was because they kept trying to continue. They ain't had nothing on me on that case, but they kept trying to keep me in jail, and I was just.
But you're on probation.
Yeah, I'm on probation.
You're alleged to have committed a new crime while on probation, right?
I wasn't convicted of a new crime.
Okay, but we're here to determine that as if you violated your probation by potentially have committed a new crime. Are you wanting to go forward with the hearing, having not seen potentially? I mean, I don't know about what's on the video, which could be exculpatory.
Yeah, I would ask to continue it to next week. I need the officer and I need the video. Okay. It's not up to him.
Well, I mean, it's up to me, I think.
It's
But
up to you.
I want to hear from both sides.
Yeah.
So, Ms. Rivers?
Your Honor, I believe that we do need to watch the video. I'm surprised by his reaction that he does want to go forward. So, go ahead.
It ain't nothing on the video. It's like what y'all trying to convict me of is nothing, man. What? I guess.
Do you understand what we're here for today, sir?
Sir?
Do you understand what we're here for today? Ma'am?
No,
He
sir,
doesn't need answers from the back. Well, but I'm talking to him, and this is my courtroom, and so I'm going to ask if you'd stop shouting out from the back. I know you're not being disorderly or anything, but I need to talk to him. So, Mr. Tatum, we're here as to whether or not we're going to have an evidentiary hearing in your probation case. The state can proceed on your violation of probation and try to prove that you violated by making a new crime, even if you've never been convicted of that crime. And it's a lesser standard, which means, beyond all reasonable doubt is what we normally talk about. The standard in a violation of probation is preponderance of the evidence, and you don't have a right to a jury trial when it comes to that. So I can make the determination based on the evidence that as long as the scale is slightly tilted against you, I can find that you violated your probation in a case where you never have been convicted of the crime. I'm not saying I'm going to do that. I just want to make sure you understand that. Now, if you were to be convicted of that crime in that case, which is the 24 CF 2304, which is also my case and is set for February 24th, if you're ultimately convicted in that case, it makes it pretty easy to prove that you violated your probation if you've been found guilty in that. So what your attorney is trying to do is make sure you understand there's more evidence that she hasn't seen yet that even the prosecutor didn't know about until yesterday. So we can bring you back next week.
Okay.
That's what your attorney is asking for.
Oh, okay.
And that's my next possible day is next Thursday. We can come back. Everyone will get a chance to see the video, And maybe that makes things better for you. I don't know. I don't know what's on the video either. I mean, I only know what you're charged with and what the allegations are. I don't get to see the evidence. A lot of people think I do, but I don't get to see the evidence until we show up and someone shows it to me.
Okay.
Okay? So, are you okay with coming back next week?
Yes, sir.
All right. So let's put them down for February 6th. Is that going to be 9 o'clock?
Well, Your Honor, it depends. If we're going to have an evidentiary hearing with witnesses, it's up
In
to
the
the court,
afternoon?
maybe in the afternoon.
Okay.
Yeah. I'm checking what we have so far for the afternoon that day.
No, we have restitution
We have 16 cases set as of now.
In the afternoon?
Yes, sir. At 2:30, yeah. I'm looking at the docket and I'm opening it. Yeah. We have one evidentiary hearing, one motion hearing. I don't know what that is.
Well, we've got 16 cases, but we've got like 5 defendants, right? Let's see. 1, 2, 3, 4, 5, 6, 7. Almost half the cases are one person. All right, so do we want to just set it for the afternoon docket? We'll put you on the afternoon docket, so it'll be, we'll say 2:30, but as soon as we finish up with the 1:30 docket, we'll roll right into that. All right, anything else that we want to talk about? Ms. Rivers, Ms. Leone? Ma'am, did you have something you needed to tell me? Well, there's a couple different things, just to make sure that everyone knows. And he's got 2 violations of probation. That's in the 2020 CF 1826 and 2020 CF 2406. And his new case. Hold on just a second.
Come on, see, you ain't even happy. You ain't
24
saying
he's charged
nothing.
with tampering with evidence and felony battery. Felony battery. Okay. All right. Anything else that we have to address? It's not question and answer time from the back, but that's the new case. All right. Yeah, I don't have answers to that. That's not, you can talk to his attorney, but you know, this is not for me to answer every question about how the system works. He's been charged with it. That's how. The state files an information or a charging document based on the officer's report, and that's how we end up in court. All right, anything else? All right, we'll see you back next week.
Who you gonna talk to?
If she gives us the video, either tomorrow afternoon if I've got the video, otherwise Monday.
Is that everybody? All right, we'll be adjourned.
10:30 Monday.